The Supreme Court dealt a blow to the Trump agenda today. In a 7-2 decision, the court decided to keep in place its order blocking the administration from invoking the rarely used Alien Enemies Act of 1798 to deport Venezuelan migrants without due process. I want to bring in Lisa Rubin, our MSNBC legal correspondent. Lisa, you have been working triple time today. Thanks so much for being with us. Can you tell us a little bit more about this decision?
Yeah, so Michelle, today's decision from the Supreme Court doesn't have to do with what I'll call the original sin. That was the Trump administration's decision and then deportation to take 200 plus Venezuelans and deport and imprison them in El Salvador, mostly in that infamous CCOT prison. That's not what tonight's decision is about. What it is about, on the other hand, is the administration's second attempt to deport Venezuelans who are alleged members of Tren de Aragua, subject to the president's proclamation of March 14th. You just mentioned that in mid-April, the Supreme Court said, you may not do that. And tonight, they're saying by a vote of 7-2, you still can't do that. And one of the key reasons is because while the Supreme Court isn't defining how much notice is necessary, the administration has been saying 24 hours is enough. 24 hours is enough time for someone to get themselves to court, hire a lawyer, file what's called a habeas petition. And the administration tonight saying that ain't it. However much notice is required, that's not due process, Michelle.
So Donald Trump took to social media to express his extreme disdain about this. But other than appealing to the court of public opinion, what is the next move for the administration?
So the administration is, the Supreme Court is sending this case back down to one of the federal appeals courts, specifically the Fifth Circuit Court of Appeals. And it's directing that court to decide two things. One is, how likely are the plaintiffs in this case to succeed on the merits? And those merits, of course, include whether or not the president actually had the authority under the Alien Enemies Act to detain and deport these folks in the first place. That will include an interpretation of the Alien Enemies Act, and in particular, the meanings of the words invasion, predatory incursion. Do those only apply in instances of real wars, as they have in the instances past in which presidents have invoked this? Or does it apply to something like this, where the president has attempted to say that where you have a mass migration, not necessarily all at once, of people who are members of a gang or alleged members of a gang, that nonetheless is an invasion or an incursion that justifies the invocation of the act? The second thing that the Fifth Circuit has to do, Michelle, is define exactly how much notice is required. And it's likely, if not almost positive, that this case will end up back in the Supreme Court's lap on appeal. The Supreme Court saying tonight the Trump administration not only can't deport and imprison these people until the Fifth Circuit decides, but that its injunction that it entered today is going to last until somebody petitions the court to have a review by the Supreme Court and the court decides yes or no. And as President Trump himself noted in a social media post tonight, that could take months. This is a huge blow to the administration in terms of how long they're going to have to wait to get an answer in their favor, if at all, with this particular class of immigrants.
But there are some immigrants who have already been sent overseas to El Salvador. Let's talk about the latest in the Kilmar Abrego Garcia case. At today's hearing, the judge scolded DOJ attorneys for releasing next to no information about what the government is doing to try to bring him home from El Salvador. We've seen the DOJ do this before. When does the judge finally just say, stop stonewalling me, enough with this?
I don't know when she's going to do it, but unfortunately for the plaintiffs in that case, it wasn't today. She's given the administration another opportunity to supplement a declaration from Secretary of State Rubio trying to justify why it is that they can't provide certain information under what's called the state secrets privilege. On the other hand, because the plaintiffs complained that they got next to no information, in part not just because of these privilege invocations, but because the people that they deposed who are supposed to have personal knowledge of what went on behind the scenes in terms of negotiations with El Salvador really knew nothing at their depositions. Judge Zinnes is telling the plaintiffs the lawyers who represent Kilmar Abrego Garcia, you can depose 3 more people who are supposed to serve in a representative capacity for the government. In other words, they're supposed to familiarize themselves with what other people in the agency know and not just with what's within their own personal experience. So again, Judge not saying today enough is enough, but I think we're getting to that point. The lawyers representing Kilmar Abrego Garcia were just exasperated in court today. They have been waiting since April, early April, as they noted, to get to more answers that are responsive to the Supreme Court's directive that the administration has to facilitate his release and return, which they conceded in a government filing was erroneous to begin with, Michelle.